The next item in agenda is related to custodial sentences and measures involving deprivation of liberty. As the next speaker, I would like to give the floor to a representative from the European Commission.
Thank you very much. My name is Jeska Bneder. I'm working for the European Commission for DG Justice, and I'm responsible for the detention framework decisions, so also the one which is on the program this afternoon, the transfer of prisoners. And in my presentation, I will tell you a bit about the legal and practical obstacles that we have identified so far in the application of the framework decisions by the member states who already implemented them. Probably after this afternoon, there will be many more items to be added to the list after the discussions that we will have with you. So I will start with the first one. This is the most important one, the transfer of custodial sentences. Normally we call it the transfer of prisoners. And this one is part of a set of measures which all have been adopted in around 2008 and 2009. The transfer of prisoners obviously relates to the transfer of custodial sentences from one member state to another. But may also include deprivation of liberty. So it may also include people who are not held liable because, for example, of a mental disorder. They may also fall under this framework decision, as well as minors, as well as children. The second measure is the transfer of probation sentences, which is an alternative sanctions, which is very similar to the one on the transfer of custodial sentences. And this relates to all type of probation measures, alternative measures. So it might be a suspended sentence, it might be a community service. And the last one is the European Supervision Order, which relates to the pretrial stage. And this measure allows a person who is suspected in another member state to go back to his home country to await the trial in his home country and then go back to the sentencing state once the trial takes place. I'm quickly running through this because I suppose these measures are already well known to you. This is the table on the state of play of implementation so far as it stands today. You can find also a very up-to-date information, as you know, on the EGN website. For the transfer of prisoners, right now there are 24 member states who have implemented. So Sweden has very recently implemented this framework decision. And right now we're still missing Bulgaria, Germany, Ireland and Portugal. They haven't notified officially to the Commission yet. Germany, they've nearly finalized their implementation, so they will probably notify pretty soon this measure to the Commission. The probation and the alternative sanctions, we're right now at 20 member states, and the European Supervision Order only 18 so far. And the UK actually decided not to opt back into the probation framework decision. They did implement the European Supervision Order recently. What is the background of these three detention framework decisions? There were the first two, the transfer of prisoners and the probation framework decision, were initiatives of member states. Because member states saw a need to actually accelerate the transfers between member states. In a way, there also are a kind of counterbalance to the European arrest warrant. The European arrest warrant is a measure which is mainly in the interest of law enforcement, while these measures are mainly, should mainly serve the offender itself. Because a transfer should always take place, it should always be in the interest of the social rehabilitation of the transferred person. So in that sense, they're also more in line with the procedural rights instruments that the EU has adopted recently, like, for example, access to a lawyer, the directive on access to a lawyer, the directive on right to information, and the recent ones on presumption of innocence, on children, and on legal aid. The reason was that the existing Council of Europe conventions, so we had for the transfer of prisoners, we had the 1983 convention, and for the transfer of probation sentences, we had the 1964 convention, were not very efficient. Under the 1983 convention, transfer might take 1.5 years from the start of the proceedings until the end. And the 1964 convention on the probation sentences was only ratified by 12 member states and was not used very often in practice. We'll quickly run through the general characteristics of the framework decisions. Well, they're very similar to the European arrest warrants. They work with certificates, competent authorities, which is particular for these framework decisions is that also administrative authorities might be a competent authority, unlike the European arrest warrant, where only judicial authorities can be competent authorities. There's an obligation to accept a transfer unless the ground for refusal apply. The ground for refusal are also a bit specific because they're all optional under these framework decisions. So competent authorities may invoke them. They're not obliged, which is rather strange because under the European arrest warrant we have some mandatory grounds for refusal, like ne bis in idem or amnesty. And we don't know actually why under this framework decisions they're optional. It's not very clear. There's no double criminality check for the listed offenses, although also here there's something peculiar, is that member states may make a declaration that they will always ask double criminality also for the 32 listed offenses. And actually quite some member states have made use of this possibility under the framework decision. A transfer can take place at the request of the concerned person or of one of the member states involved. And however, there's no obligation to transfer for the issuing state. And this is a very important point, and there's also lots of confusion on that. There's no right to transfer. So if it's requested by the prisoner or by the executing state, the issuing state is not obliged to cooperate. And this, of course, is because it might be needed that a person stays in the sentencing state because they're victims still in this state, or other reasons, or the issuing state might not agree, for example, with the adaptation of the sentence, so might not be willing to transfer the sentence to another member state. Time limits, very strict time limits, 90 days for the transfer of prisoners plus 30 days for the actual transfer of the prisoner. The adaptation of the sentence. Under the framework decision, there's the principle of continued enforcement, and this is different from the principle of conversion, which was existing under the Council of Europe Convention. And continued enforcement means that the adaptation of the sentence is only possible if the nature or the duration of the sentence is incompatible with national law. So for the nature, you could think, for example, of a life sentence, which does not exist in a member state, will then be adapted to, for example, a 20-year sentence. The duration, we can think of a maximum penalty, for example, maximum penalty for drug offenses in some member states. Another very important point is that under the framework decision, the consent of the prisoner, of the transferred person, is not always required. And there are three very limited circumstances where it is not required. It's not required when a person goes back to his state of nationality, where he also lives. It's also not required when the person will be deported after having served the sentence, or when the person has fled to the executing state. However, the social rehabilitation, as I already mentioned, should always be assessed. So the opinion of the prisoner should always be asked, also if the person will be transferred without his consent. Competent authorities. I already said that judicial administrative authorities may also be a competent authority under the framework decision. This might give rise to problems, and then I mainly think of the situation where the administrative authority has to adapt the sentence. In some member states, it will not be a judge deciding upon the sentence to be executing in the executing state. Another issue is that some member states have appointed all their judges as competent authorities, as under the European arrest warrant. We have always, from the start, we have been advising these member states, if possible, to appoint not one competent authority, but at least one clearinghouse, in particular for incoming requests. And also because we think it's important that there would be one central authority which would be able to develop knowledge and expertise, and in particular in the adaptation of the sentence, and which can also function as a help desk for the national judges actually dealing with these framework decisions. And now I come to one of the probably most problematic issues under the transfer of prisoners framework decision, and that's the regime of subsequent decisions. The general rule is that the executing state is responsible for subsequent decisions. And that also includes the ground for early and conditional release. So that means that a person might be released much later in the executing state than it would be in the issuing state, for example. Some member states have an early release after 1/3 of the sentence, some have after 2/3 of the sentence. However, member states may provide that the decision on early release will take into account the provisions of the issuing states. Not many member states have made use of this provision, actually quite surprisingly. And the executing state also needs to inform the issuing state on the early release provision. So if the issuing state does not agree with the early release provisions of the executing state, it can decide not to go for the transfer, actually. There's some case law of the court in Strasbourg which has said that in principle a longer de facto sentence is not in violation of Article 5 of the Convention, only when it's a flagrantly longer de facto sentence, then it can be problematic. Another quite problematic thing is the definition of social rehabilitation. There's no real definition in the framework decision. There are some criteria which are mentioned, and this is the person's attachment to the executing state, whether it's the place of family, linguistic, cultural, social and economic links. Social rehabilitation should not be understood as rehabilitation in the criminal law sense, that the person would have the best reintegration program or so in another member state, for example. I think it should be more understood like social reintegration. Where would the person go to after having served his sentence? And to decide on the social reintegration, often the habitual residence, the lawful and ordinary residence, is relevant. But there is also no definition in the framework decision. So does it mean that you have to live 5 years in a member state, or can 1 year already be sufficient? So probably this might give rise to quite some differences in application between the member states. The consent issue. As I said, in these 3 limited circumstances, no consent is required. But one of the problems is that is the person really able, also if the person can give its consent, to make an informed decision? Are we aware of the early and conditional release provisions in the different member states? Another issue is the differences in detention conditions, which are quite big. The second thing is the sanction modalities. How do we, problems which will come up with conversion, and how do we determine the sentencing equivalence? In some member states, for example, you have electronic monitoring as an execution of a prison sentence. But the question is, how do you convert this into a national system who doesn't know such a type of sentence? Is electronic monitoring of 5 years equal to a prison sentence of 3 years, for example? How do you decide all these issues? Offenders with mental health issues. This is also a ground for refusal on the framework decision. But of course there are huge differences in the treatment possibilities in the different member states. So how do you ensure that a person will get the same treatment once he's transferred? Pre-sentence reports. Normally in a national criminal proceeding, judges make use of these reports, and they're extremely important also to know more about the person, to know more about the supervision or the follow-up, the aftercare also by the probation services. Under the framework decisions, there's no obligation to transmit these reports, and mostly these reports are drawn up in the national language. So are we going to translate everything? We need to see how this will work out in practice. Combined sentences. Some member states, they impose mixed sentences, cocktail sentences. So these comprise of a custodial sentence and an alternative sanction, or a custodial sentence and a financial penalty. How to transfer these type of sentences? Do we need 2 different certificates? That also has to be seen in practice. Legal remedies, I will quickly run through. Some member states provide for legal remedies up to the Supreme Court. Other member states only have 1 instance of appeal. Victims, what is the role of victims? Are they informed of a transfer that will take place? And what is the link with the European Protection Order? We might also touch that topic this afternoon, because you can get very complicated situations once a victim moves to another member state and the offender also moves to another state. And how do these 2 measures interact? The increased importance of detention conditions. That will also play a role for the transfer of prisoners framework decision. We already had the issue, of course, was already mentioned in relation to the European arrest warrant. But the possibility of transfer of prisoners without their consent, of course, increases the importance of observance of human rights standards. And we have seen in the context of the European arrest warrant, we see more and more cases where judges are refusing to surrender people to another member state because of appalling detention conditions in the executing state. In the recitals of the European arrest warrant and also of the 3 framework decisions, it reminded that the framework decision respects fundamental rights. However, it's not a ground for refusal under the framework decisions. Although I have to say for these framework decisions it's less problematic than for the European arrest warrant, because under these framework decisions, as I mentioned, the issuing state is never obliged to transfer a person. So the issuing state, if a judge in the issuing state is not convinced that the detention conditions in the executing state are appropriate, there's no obligation. And of course this is different from the European arrest warrant, because in the European arrest warrant there is an obligation to cooperate unless the grounds for refusal apply, and fundamental rights is not a ground for refusal so far. But of course we have case law in the field of asylum, in the field of migration, and where the European Court of Justice has actually indicated that there is an obligation for member states to investigate the reality facing prisoners, that there cannot be blind trust. We do not yet have an answer in the field of transfer of prisoners, but this might come up. We might expect a decision which might be similar to the MMS case or the NS case of the Court of Justice. Well, I just mentioned many issues and many challenges that we actually have to deal with in the coming years. And we also have been thinking of what the possible solutions could be. I think it's very important that we increase the knowledge of the member states' legal systems so that the sentenced person will be able to make an informed decision once he applies for a transfer. That is both on the prison regime but also on the sentence execution modalities. So what would be very useful is, for example, to have a database with information on the early and conditional release provisions of the different member states. And in this sense, communication is also very important. I think it's important to start networks so that people get to know each other, so that people have a face-to-face contact and that they can easily pick up the phone and arrange for a transfer. This will be similar to the European arrest warrant, but we do not have these structures yet for these instruments. Training of judges, public prosecutors, defense lawyers, but also prison staff. Many prisoners are not aware of their rights, so it might be good if prison staff or defense lawyers could inform them of the possibilities to serve their sentence in their home state. An early warning system. Some member states use a system where the prosecutor is already aware of the offender's residence, the offender's permanent residence, not just his nationality. And on the basis of this system, the case is presented and the judge is directly aware that this person might qualify for transfer. I think that's very important in the sentencing stage already. And member states should also identify the partners they will cooperate with closely. And regional meetings might also be important in that respect. What has the EU done so far? Well, we have always, we had the problem of the poor state of play of implementation. The deadline for the implementation of this framework decision was in 2011, and you have seen the numbers, so they're not very convincing. So from the start, the Commission has organized implementation workshops, expert meetings, and we also drafted an implementation report on the 3 framework decisions on the 5th of February 2014, also to remind member states of their obligation to implement. The Commission will have the possibility to launch infringement actions from the 1st of December 2014. Right now we are analyzing this, the situation. We are analyzing which member states have not yet communicated, and then we will decide. Probably we will first focus on the non-communication. So and after that we will also have a look into the legislation, whether it complies with the framework decision. We're planning to draft a handbook on the transfer of prisoners framework decisions. We're also working on a handbook on the European arrest warrant, and we want to align these 2 handbooks, a handbook which should be easily usable by legal practitioners. It should be really written for judges and prosecutors in the first place. Well, to promote the discussion, we have special interest groups. Europris is very active on the framework decision of the transfer of prisoners. They will have a meeting in the beginning of July, and normally they have yearly meetings with competent authorities of the member states, which are extremely useful, where practical experiences are exchanged and which are very helpful also for member states who did not implement yet. And then we have some projects that we fund. A very important project in this field is the STEPS 2 project. And there's a study currently going on by the Fundamental Rights Agency. And this study is about the 3 framework decision and mainly focuses on the fundamental rights aspect. So how is the opinion of the person taken into account, and what happens, I mean, in case of a transfer to a member state where detention conditions are below standards. Then we would like to provide assistance in the practical application. So we're working on the e-justice website. As you know, the EGN website will be integrated into the e-justice website. But we would very much like to elaborate on that website and really make it a one-stop shop, also where, for example, you could transfer certificates. It's a quite ambitious project, and it will take quite some time to launch it properly. And finally, we would like to work on the development of fact sheets for the implementation of the framework decisions. So fact sheets for each member state on early release conditions, and also, for example, a travel card for prisoners with information, one sheet of information where the medical information of the prisoner or all other type of information in English or in another language is mentioned. I think I leave it here. Thank you very much.
Thank you, Jessica. I'm Florentino Reese, judge from the Appeal Court of Huelva in South Spain. I would like to have my PowerPoint presentation, if it's possible, please. And let me start by expressing my thankfulness to the Latvian Ministry of Justice and to the European Judicial Network for having invited me here. I've been a judge working at the Appeal Court for over 12 years, dealing, amongst others, with appeals coming from the Penitentiary Surveillance Court of our province. We do have such courts in Spain taking care of the enforcement of custodial sentence, and that has kept me in close touch with the penitentiary world, let's say. Additionally, I'm a member of the Spanish Network for International Cooperation in Criminal Matters, and we are receiving an increasing number of queries related to Framework Decision 909 we've just implemented in mid-December last year. And finally, I happen to be a researcher in that project Jessica has already mentioned, Steps 2. This is a project run by the National Offender Management Service from the England and Wales, and with the participation of universities of Ghent, Brescia, Montfort, and Huelva, which is the city I'm based. I would like to very briefly flick over the framework decision, just pointing out some points of controversy or points of interest, and I'm going to flick even over my own presentation because I would like to go to very specific points and problems related to practice, but all of these from the perspective of the sentenced persons, from the perspective of the inmates, as we usually call them in the context of Project Steps 2. Social rehabilitation is not only the ratio legis of the framework decision or the paramount objective. The social rehabilitation, in my view, is the key. We need to turn to get the engine running. Without social rehabilitation, we can't do anything. The problem is the social rehabilitation is not defined by the framework decision. What we have in Article 3 is a reference saying that social rehabilitation needs to be assessed to put the machine into work. And in Recital 9 of the preamble says that to assess social rehabilitation, we got to look at the attachment of the person, taking into account family, linguistic, social, cultural, or other links. What I would like to convey is social rehabilitation here. We are dealing with people in prison, so social rehabilitation need to have one more ingredient, and that ingredient is that coming from prisons. So we shouldn't not think about the social rehabilitation outside prisons, but how to match the conditions in prisons, the prison regime, and the prison respect for fundamental rights and rules for early or conditional release, for permits or whatever, linking that with social rehabilitation outside the bars, let's say. Because if I had my family back home, but I cannot benefit from permits, or the conditions in prison are very poor, we need to assess and balance what happens. In reality, in practice, we have very short practice in Spain, but the first case we have issue a certificate and transfers a sentence was from a very court in Huelva. And in that occasion, the person was serving sentence in France. He didn't mention a single time the word social rehabilitation. His only concern was picking up the sentence he was serving in France and the sentence he was going to serve in Spain, because the outcome of picking up those combined sentences will be 2 or 3 years less than going one first and then the other. And we, as a sentencing court, we didn't mention a single time the word social rehabilitation, since we took for granted that sending a person to his homeland would be in favor of social rehabilitation. And it's not always like that. Could be or could be not. Moving to the consent, Jessica has already mentioned that we need the consent of the sentenced person and the consent of the executing member state. Let's go first to the consent of the executing member state. that is required only when the person is not required when the person is going to be sent to the member state of his or her nationality where he lives, or to the member state where he or she is going to be deported. What happened yet again is the framework decision doesn't give us a definition of where the person lives, and it has caused that member state word in different manners that of where the person lives. And this is crucial, because depending on where the person lives, how we take this concept, her or his consent is going to be required, or the member state, executive member state, is going to be required or not. This is a problematic point. And when we don't need the consent of the executive member state, we always have to resort to at least its opinion. And first problem is this, and the second problem is when the person is going to be deported, whether or not the executive member state is entitled to review the lawfulness of the deportation, because deportation of people, citizens of the EU, is a very exceptional circumstance, based only on public order, public security or public care circumstances that appear up to a great extent. Whether or not the executive member state is capable to assess if the deportation is lawful or not is an important matter as well. Whether or not the executive member state can refuse the transfer, invoking those grounds, invoking Article 9, or invoking fundamental rights related points. It's a matter for a deep debate indeed. Moving to the sentenced person consent, problems are more or less the same. Is not required when he's going to be transferred to the member state of his nationality where he lives, or to the member state he's going to be deported, therefore the two same problems. And third, is not required when he's going to be transferred to a member state he has fled or otherwise returned in the view of the proceedings or the conviction. As for the last circumstance, it's not easy always to assess if the movement of a person from member state A to member state B has been due to the fact that he's facing proceedings or he's facing a conviction. We need to be careful and put the magnifying glass over this matter and check out whether his consent is going to be required or not. As for the sources of information regarding social rehabilitation, we have issue member state reports and data, executive member state reports and data, and the very convicted personal point of view. In my view, this is the most important of the three, because we can imagine that the person could say, well, my consent is not required because I have my roots back in Spain, but I'm telling you that I've raised a new family here, I have a new partner here and a couple of children with her, or there is a gang back in Spain that threats me, telling me I'm killed if I step on their prisons, or there is a gang it's going to force me to go back to the crime track. So we need to be very careful if those are the statements of the sentenced person, because we need to check out whether or not this matches with reality, because it's very important. Disregarding that, according to framework decision text, his consent could be required or not. And this happened. Lastly, as for the consent of the sentenced person, I would like to mention that unlike the framework decision on European arrest warrant, this framework decision doesn't mention the possibility of that consent to be revoked, and doesn't link the consent with the speciality principle. And those are areas that may give rise to problems as well, because I think, and we can think, that the consent could not be revoked, but what happens if the circumstances have changed? Well, I gave my consent 5 months ago or half a year ago, and now my situation is different. I think we should reassess the status of that person and decide whether or not now is still applicable that of his transfer is going to be in favor of social rehabilitation. And with specialty principle, things are quite hard as well, because if you go to Article 18, it seems to link, in all cases, consent to the renouncement of the entitlement of specialty principle. And it's a very subtle point. Moving very rapidly to human rights concerns, as many frame of decision, this 909 says that when applying frame of decision, we need to respect fundamental rights as set out in Article 6 of the Treaty of the European Union. This means that all the time we need to check out what happens with fundamental rights. We all member states, we are members of the Convention of European Convention on Fundamental Rights, but we all know that sometimes Strasbourg Court says that we are violating the Convention. This is a reality that we do need to check. And in that case, the interesting point could appear when, as for the fundamental rights, the conditions in the executing member state to be poor or are quite unacceptable. But on the other hand, you can find that the period of time to be served in that country is shorter than in the issuing member state, or their links with the family could be enhanced. Well, you have different incomes, and you need to balance very carefully, but always with that north point of social rehabilitation that needs to be always handy to operate with 909. Let me move briefly as well to the technical aspects. And the first slide has to do with commencement of proceedings. The proceedings could be started by the issuing member state, by the executing member state request, or by the sentenced person request. As Jessica have said, there's no obligation for the issuing member state to transfer the person. It's not compulsory, but what to do when we have different requests? I mean, the sentenced person asks him to be transferred to Greece, and the executing member state is going to be France, and even the issuing member state is thinking about sending him to Italy. Well, we need to, there's how to prioritize. We don't have rules in the frame of decision, so we need to go to, yet again, balancing social rehabilitation. Could be most favored in France, in Italy, or whatever. It's a matter to think a bit about. Second thing, very important, is the information flow from the penitentiary authorities to judicial authorities and to the very sentenced person. As we've seen in Spain, as for our short practice, there are huge differences depending on the involvement and the attitude of the penitentiary authorities. For instance, in my province of Huelva, it's a very small province, it's a medium province in Spain, we have dozens of certificates already issued because penitentiary authorities, the vice deputy of the prison is a member of Steps 2 as well, she's a researcher as well, he's very committed with that idea. So he puts forward a lot of cases, and she's in very direct contact with the penitentiary civilian judge. Therefore, they are issuing lots of certificates. Whereas in other provinces bigger than mine, and with a more important population of people from abroad serving sentences, they haven't sent any certificate yet. So that speaks volumes about the importance of the commitment of penitentiary authorities, because they are in touch with the sentenced person. As for the time limits, we are thinking in Steps 2 as one of our conclusions to propose that as guidelines or rules of best practice, suggesting that as the existing time limits for the execution, to set out as a guidance time limits for the issuing, because we have found that sometimes from the moment the person asks for him to be transferred until the moment the issuing member state authority decides to issue that certificate, months could have passed, 8 months, 9 months, and a rather unacceptable period of time for the certificate to be issued. Very important, already touched by Jessica as well, is the matter of the information flows. The one who needs to be informed is the sentenced person. He or she could be informed by the penitentiary authorities or by the judicial authorities, but he needs to be informed about the possibility of the transfer. Many of them don't know about such possibility, about the proceedings of the transfer, about the consequences of the transfer, whether you have to consent with the transfer, you have to know that specialty rule doesn't apply, or you need to know that even you can have transit issues, because if you carefully read Article 16, you can have transit issues, and you need to be aware about what the prison conditions and the prison regime and the prison and the enforcement rule in the executing member state to be are. Very important as well from our field work is what the prisoners are interested in. In Romania, we are working closely with Romania and Italy mainly. In Romania, we have thousands of inmates from Romania. We have prepared a brochure, a very brief brochure, 2 pages, and we have disseminated it in Spain. Prisoners are mainly interested how much time I'm going to be serving if I'm transferred, what prison I'm going to be served. They don't want much information, but they want to know just basic. But as for those basic, they must be aware. This is very important to circulate information and to make those people aware of the possibilities. The second important flow of information is between issuing member states and executing member states. And yet again, going to field work, what we have found is sometimes if you send a person abroad without informing the executing member state authorities about the status of that person in prison, you can be we can be missing a very important piece of information. For instance, the inmate is in Spain benefiting from permits every 2 months. He's in a very advanced degree of his treatment. He's benefiting from intimate visit. He has got a number of awards and so on and so forth. If you transmit that person abroad without giving such information to the executing member state authority, probably when he enters into prison, he's going to be sent back to the starting point, and it would take months for him to reach such an advanced position in the enforcement pathway. So this is important to provide the executing member state authorities with such information. So we are thinking in steps to prepare a proposal of an integrated protocol, a series of checklists and forms facilitating that exchange of information between international authorities, between penitentiary and judicial authorities, as an aide-memoire or a checklist to remind us what is important to convey if we're talking about adaptation of the sentence, or if we're talking about social rehabilitation or prison status or whatever. Moving now to the enforcement. Yes, this has been touched with Jessica as well. The enforcement, the law governing the enforcement is that of the executing member state. There are some exceptions you can find in Article 17, but this is important to know that according to Strasbourg case law, if the person is sent to a country where he or she is going to be serving a longer period of time, this is not automatically in breach of Article 3 of the Convention. This is perfectly admissible. But however, we need to assess, yet again, if that period is longer up to a point that is colliding with social rehabilitation or not, because we need to think all those things and sifting them throughout the filter of social rehabilitation all the time. As for the ground for refusal, the report of 2014 from the Commission is not very happy with the attitude of some member state that has enforced some grounds for refusal as mandatory. This is the case of Spain. All the optional grounds for refusal are mandatory in our country since 2014 Act. And some member states has added up some additional grounds for refusal, and the Commission says this could be against the spirit and the aim of a framework decision. The adaptation of the sentence, we follow a system of continuation rather than adaptation, but we can adapt sentences in two events, incompatibility as for nature or duration. The important thing to bear in mind, as soon as we know what we're talking about, the better. If we can do that before transferring the person, the better, because that way we can withdraw the certificate. So it's interesting to have yet again rounds of consultations between issuing and executing authorities to make clear whether or not there's going to be an adaptation or what the result of such an adaptation could be. And I would like to quote a very recent case from 2014, a preliminary ruling from Bulgaria, Gayanov case. I'm not sure how to pronounce this. And the questions put forward by Sofia court were three. Well, you know, Bulgaria hasn't implemented 909 yet, but there is an ongoing preliminary ruling. Could we adapt the sentence taking into account the period of time the person has worked in prison in the issuing member state? Number one. Number two, could we do that up to the extent of reducing a period of time longer than the period of time actually served by that person? And third, if we're not entitled to do so according to Article 17 of Framework Decision, can we directly apply our national law because this is not against union law and is more beneficial for the sentenced person? Well, I'm pretty much interested in seeing what Luxembourg court is going to say regarding those three questions. And I'm closing by saying something about transitional period. Transitional period, as you all know, has expired long ago in the year 2011, but we have 4 member states that haven't already implemented 909. The problem related to practice, I live in a border region, border with Portugal, so in a prison we do have a lot of people from Portugal, and the problem is whether or not to transfer those people to Portugal resorting to 909, or are we obliged to resort to Convention 1983? As I'm a contact point of a national network for international cooperation, I do some researches in Portugal, and there are 5 courts in charge of these matters of receiving requests, 5 tribunais de relação. And we've been told that only one of them, in one case, has applied 909. But they thought, contact point from Portugal, thought that the safest way was resorting to Convention of Strasbourg. Nevertheless, I recommended the penitentiary civilian judge of our province to resort to 909, to invoke the Pupino doctrine, and to invoke the direct effects and supremacy of European Union law. And let's wait. Let's see what happens, because the waste of time we're risking is minimum if you compare to the time it's going to take going through Strasbourg Convention pathway. So I said there, well, let's send to different parts of Portugal and let's sit and wait what happens. Last thing, I'm going to give a miss of all the rest because I would like to stick to the time I've been given. Last thing is identity of sentenced person. Yet again, from practice, we've seen that some people, when commit a crime in Spain, either before or after having committed the crime, they get rid of all kind of documentation. So we have an important number of people in prison, even from some member states that do not have the documentation at all. And we are facing a problem here. We are trying to resort to consulate authorities, to resort to Interpol. We are searching different ways to get documentation, travel documents for those people, because we are in the light that sending people abroad without documentation would not work. very efficiently. But I've read in the report of Europris 2013 that apparently in Austria they don't have many problems regarding this matter. I would like to talk later on with the Austrian representative because I'm pretty much interested in getting to know how they deal with this matter, because for us we are finding it really complicated transfer person without any kind of documentation. Thank you very much for your attention. Thank you.
Liels paldies par tik precīzu laika ievērošanu.
Thank you very much for observing the agenda. It was very accurate. I would like to thank also Mrs. Jessica Bender for the introduction into the legislative process. It was very useful to find out about the state of play in the implementation of instruments. However, to Mr. Florentino, I would like to thank for the practical aspects and issues related to transfer of sentenced persons. I believe that today and tomorrow we will manage to find solutions for those issues and challenges. However, we now have a longer coffee break. Therefore, I would like to invite us all to go now on coffee break and meet back here at 11 and 10 minutes. Thank you.